said on May 15, appellant put in a request for transcripts. On May 21st, appellant received email from Patty Petts, official court reporter, Luzerne County Courthouse. He said transcripts will cost $1,000. These costs will need to be paid up front before transcription begins. Are you still interested in moving forward? Patty Petts was the transcriber for 8/31/23 PFA hearing. Patty Petts has taken over communication for day one of trial court transcripts 10/3/23 that was recorded by Bernadette Farron. When appellant initially inquired about transcripts, Patty Petts began communicating with the appellant in regards to transcripts that were recorded by another court reporter. Appellant thought this was unethical considering any transcript in the past has been handled and communicated by the stenographer who transcribed the proceedings. Appellant had not reached out to original stenographer Bernadette for 10/3/24 transcripts after filing transcript requests on May 15. Patty Petts took over all communication regarding transcripts and interfered with proper communication between original court reporter and appellant. On May 30, 2024, appellant spoke with Patty Petts in person regarding reduced transcript price. Patty Petts stated, "You cannot get a discount on transcripts. They must be paid in full." Appellant explained he would be attending an IFP hearing on May 31st to receive a reduced price on transcripts. Patty Petts explained she has been working as a transcriber for many years and has never seen transcript fees waived. The following day, May 31st, appellant transcript IFP was granted. Appellant proceeded to court reporters to submit a court order dated May 31st, 2024, waiving transcript fees. Order was received by court reporter Patty Petts. Patty Petts proceeded to question the appellant's financial status. Patty Petts challenged whether appellant was within the poverty threshold and questioned appellant about tax returns and then stated, "You claimed in one of your hearings that you were making $40 an hour and you have a lucrative business." Leah Nelson corrected Patty Petts and stated it was $38.50. Patty Petts then repeated the correct dollar amount and then proceeded to tell me, "We will find out about your income through domestic relations, child support." The appellant explained that the subject child was in a very bad predicament and I've been using all of my time and resources figuring out how to get the child back home and out of harm's way. So I have not been working as many hours as I usually work. The appellant also explained I was making $38.50 an hour in 2017 while working a prevailing wage waste removal job at a local bank. Patty Petts then proceeded to inform me that they will not start any transcripts and that she would have to look at the rules regarding the 125% poverty threshold. These actions are unethical, illegal, inappropriate, and gives reason to believe attempts to retrieve transcripts are being sabotaged. Furthermore, my personal business is being discussed among court reporters outside of the courtroom. Appellant did not hear anything regarding transcript production and decided to email court reporter Patty Petts regarding transcript status on June 4, 2024. Patty Petts responded on June 6, 2024, stating the transcript of 10/3/23 is being completed by Bernadette. As soon as she is finished and the judge signs the original, a PDF copy will be emailed to you. The 8/31/23 hearing was taken by me. I will be completing the transcript in due course. As I finish the transcript and original is signed, a PDF copy will be emailed to you. So trial court quoted 10/3/23 transcripts on May 3rd, 2024, court order on page 15 of trial court opinion suggesting 10/3/23 transcripts had already been transcribed. On June 13, 24, appellant sent message to PP that states, "It appears the transcripts from October 3, 23 have already been transcribed." Appellant received a response from Patty Petts on June 13, 2024 at 9:13 a.m. that states, "I've been in touch with the court reporter who took the 10/3/23 hearing. She has informed me it is not finished. I am unsure what completed transcript you are referring to. Since starting your transcript, she has had to switch to working on a fast track appeal that takes precedent. As soon as she completes your transcript, please be assured that it will be immediately sent to you after the judge has signed the original and the court reporter has filed it. As for the 8/31/23 transcript, I am hopeful to begin editing it by this weekend and will contact you by the end of next week as to its completion." Appellant showed up to the court reporter's office June 13th at 10:30 a.m. with a copy of Judge Toohill May 3rd, 2024 order. Appellant highlighted line 11 of page 15 of that order, which quotes page 171 of the October 3rd, 23 transcripts. Court reporter Patty Pett stated, "This is the wrong date. I know this was a mistake. Judge mislabeled the date." Patty Pett then advised me she would go to the chambers to figure out how the judge mistakenly quoted transcripts from another date. Patty Pett sent an appellant email on June 13, 2024, 11 a.m. that states, "I went directly up to the chambers. They are reviewing this matter. As soon as I get communication from chambers, I will notify you immediately." On June 13, 2024, 12:47, appellant received an email from Bernadette Farron with the PDF transcript. Transcripts revealed there was no mistake in May 3rd, 2024 order. Judge has in fact quoted page 171 of October 3rd, 2023 transcripts, day one of custody trial. Appellant has reason to believe trial courts and officials have obstructed justice and interfering with transcripts in a fast-track children's appeal. Appellant continues to be respectful to Patty Pett despite past and ongoing aggression. Patty Pett has yelled at appellant during court proceedings in the past. The appellant has experienced ongoing unprofessional behavior from trial court, chamber secretaries, and court reporter Patty Pett in 2023 and 2024. The relationship between attorney Maura Tunis, appellee's attorney, Judge Tara Toohill, Judge Toohill Chambers, Joel, and Nicole, and court reporter Patty Pett is unbelievable. Appellant often feels like he is in a high school setting and being bullied. The criminal actions and unprofessionalism is appalling considering we are in the United States courthouse of justice. My civil rights and the rights of my autistic 11-year-old daughter are blatantly being violated on a consistent, nonstop basis. This behavior by public officials violates the Constitution, 18 U.S.C. 371, conspiracy to commit offense or to defraud the United States, 18 U.S.C. Section 241, conspiracy against rights, 18 U.S.C. and Section 242, deprivation of rights under color of law. Court reporters are expected to remain impartial, steer clear of conflicts, maintain confidentiality, uphold high standards of integrity, and safeguard the transcript. Appellant believes that Patty Pett's unprofessional personal relationship with the trial court, judges, secretary, and attorney has clouded her judgment and caused a toxic environment for appellant. The National Court Reporters Association sets the benchmark for ethics and professionalism. The NCRA emphasizes the need to safeguard confidentiality, ensuring that what happens in the courtroom stays in the courtroom. The Pennsylvania Court Reporters Association Code of Professional Ethics states a member shall be fair and impartial toward each participant in all aspects of reported proceedings and always offer to provide comparable service to all parties in a proceeding, preserve confidentiality, and ensure the security of information, oral or written, entrusted to the member by any of the parties in a proceeding. Refrain as an official reporter from activities that interfere with official duties and obligations, maintain the integrity of the reporting profession, abide by the Pennsylvania Court Reporters Association bylaws. Appellant also requests parental rights be restored before brief due date, considering trial court illegally removed parental rights from subject child's father, protector, and advocate, and gave rights to appellee who has showed beyond a reasonable doubt to be a danger to the child. Child safety and well-being is at stake. Appellant suggests a verbal in-person emergency hearing would assist Superior Court in seeing factual evidence that trial courts are unlawfully going against the best interests of the child despite the harmful effects it is causing to child and appellant. Trial court actions willingly and unlawfully have mentally, emotionally, and physically abused the child in 2023 and 2024. Trial courts willingly and unlawfully mentally and emotionally abuse appellant repeatedly in 2023 and 2024.